Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, where the Wi-Fi usually works. But not always. Not always. Where do I have it? Where do I have it? I wasn't ready for this. Oh yeah, I'm feeling it. Let's do this thing.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patna number 12.
Ryan Hummer to the podium and Francisco Campo to the chair, please.
Okay, I have to thank Mike myself for sending this to me, and it's from a channel. I put a link to the video in the description. There's a much longer video. I just took one small segment from it, and it's called, what's it called? It's called Benchside Broadcast. I think I've gotten a clip from there before. It's good stuff. Thanks a lot. Let's do this thing, shall we? Oh, yeah, it's a subset. I'm not even going to discuss the stash on the judge.
Good morning, sir. May I have your name and date of birth?
I'm an attorney in fact for Ryan Neal Hummer, agent, and date of birth April.
Is your name Ryan Hummer?
I'm the attorney in fact for Ryan Hummer.
Sir, that's not what I'm asking you. Is your name Ryan Hummer?
I am the agent for the attorney in fact and the attorney in fact.
When you were born, what was your valid name?
Ryan Neal Hummer. I was.
We're here today on a Superior Court arrest warrant. You were arrested.
There we go. That's what we thought. Well played, Judge.
On allegations of 1 count of stalking, fear of death, a Class 3 felony, and 2 counts of computer tampering, Class 5 felonies. I will affirm the attorney that was already appointed to represent you in this case. I'm setting a status conference post-warrant on September 19th at 8:30 in the downtown Superior Court. I am going to affirm the bond that's in the cash, or affirm the bond that's in the warrant as a $7,500 bond on this case. I'm also ordering pretrial services, supervision, and an electronic monitor to be installed if you do post that bond. We're also here today on a second arrest warrant on a case involving 1 count of monitoring device interference, a Class 4 felony, and escape, a Class 5 felony. I will appoint you an attorney in that case as well. Set a status conference post-warrant on September 19th at 8:30 as well in the downtown Superior Court. And I am ordering a cash bond in the amount of $7,500 with pretrial services, supervision, and electronic monitoring to be installed before your release on that one as well. You'll have the same release conditions on both of these cases. I'm ordering that you not return to the scene of any alleged crime, no contact with any victims, complainants, or witnesses, no contact with the arresting officers, no weapons, drugs, or alcohol, and you must obey any terms of any order of protection or order against harassment that has been or will be issued. Finally, I'm ordering that you may not initiate any contact with any alleged victim for any reason, whether that be direct or indirect contact, such as through third parties or social media, nor respond to any contact from any listed victim. Any violation of a no victim contact order could constitute aggravated harassment, which would be an additional felony allegation. All of that will be in your release conditions. Do you have any questions?
No, Your Honor. Thank you, Your Honor. You have a nice day, Your Honor.
You go ahead and grab that to your left and take it.
Yes, Your Honor. Thank you. Thank you.
Francisco Campo to the podium. And Yvette.
Boom. Converted him with a little angst and the stash. Just I'm not putting up with this. By the end, he's wishing him a good day.
Uriarte to the chair.
Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights.
Good morning, iPhone. Can you identify yourself, please? Good morning. Can you identify yourself, please?
Bianca Lee.
Miss Lee, welcome. All right, we lost you for a second. We thought you might just be coming straight back. All right, let's see if we can get Mr. Wesson in here. Mr. Wesson, did you connect?
Yes. Can you hear me?
Okay. Yes. All righty. Okay, we are on the record in the matter of Lee versus Wesson, case number 18-05648DP.
Okay, this is fantastic. I have to give thanks to Rocky Lennon for sending it to me. This is the most Karenest Karen that ever did Karen. I mean, she is insufferable. You'll see right to the bitter end.
Ma'am, I've read your motion.
And it is a bitter end.
It appears that you believe that his mother is exercising a majority of the parenting time. What's going on? How much time do you think? Because you don't seem to have. You're making really blank statements about what you believe. So what's going on?
Yeah, it's not a what I believe. It's a what I know. This is an everyday thing. This has always been his mother exercising the rights. This has been the child just turned 7. It's always been me and the mother. Doctor's appointments, conferences.
Well,
anything.
What is your work schedule?
Right now, I'm not working.
Okay, Mr. Wesson, what's your work schedule?
I work Monday through Friday. I work starting at 5 a.m. to like 1 o'clock.
Okay.
Exciting and new.
Available for doctor's appointments?
Sometimes I'm not. Just depends. I'm not available for all doctor's appointments. No, okay. I don't take him to school. I pick him up from school during my week.
You pick him up from school during your week?
I pick him up from school every day during my week, and I attend.
Miss Lee, what's your understanding of that?
My understanding of that is that I have another child that goes to the same school as the child that me and Dominic shares, and I'm at the school every day picking up my child, my daughter, and the grandparents are picking up our son. Now, for the first time in a very, very, very long time, I seen him yesterday picking up our son, and I was pretty shocked. But like I said, that was the first time in a very, very long time.
Oh yeah, she's snooping because she happens to be at the school with a child from another baby daddy. That's what we're dealing with here.
I guess my questions become this. You had a hearing with the judge in 2023 over this similar issue that you wanted to disallow the grandparents from watching the child during daycare, and then you couldn't find daycare. You lost your job because the grandparent wasn't watching it because the grandparent was also watching the child during your time, correct? Is that still happening?
No.
Who's watching the child when you have the child?
When I have the child is at school or at the Boys and Girls Club.
Okay, because you're not working right now. How long have you not been working?
I just stopped working. It's just been a week.
Okay, so you're going to be going back to work. What is your normal work schedule?
My normal work schedule is from 12 to 8:30, 12 p.m. to 8:30 at night.
Okay, and who watches the child when you're at work?
So usually I'll get off. I'm work for Urban League. I'm a cure violence interrupter.
Okay, that wasn't the question. Who watches the child when you're at work?
He's at school and then the Boys and Girls Club until 7 p.m. and then I'm done.
Okay, so you have the Boys and Girls Club watching the child.
Yeah.
Boom. Ouch. I don't want him to have the kid because the grandparents are watching him. The kid is better off with me so that the Boys and Girls Club can watch him. Obviously, she doesn't give one hoot about the kid. She just wants to hurt him.
Yep, from 3 to 7. 3:30 to 7.
And he has his parents watching the child when it's necessary during his time. And it's my understanding that he lives with his parents, correct?
I'm not sure.
That's correct.
Okay, I was going to say that's what the file says. You know, at this point in time, ma'am, you had a hearing in 2023 with the judge that granted the same relief. The front of the court issued a recommendation in March of this year doing the same thing, all involving the grandparents and who's watching the kid. You both have the kid being watched by third parties upon occasion. And he's living there, so he's got to be with the kid. I'm afraid your motion's denied at this time. This has been reviewed. This has been reviewed twice in the past year and a half.
And I'm going to keep filing motions until y'all do something about it. Y'all want me to share 50-50 custody. Y'all want me to share 50-50 custody with a person that is not exercising their 50-50.
How did he ever let this delicate flower go? She's shouting down the judge who just stone cold busted her, but nicely. And she's going to try to shout that down. That's to a judge. Imagine what she's like at home. Sweet Jesus.
Custody. It just does not make sense to me. Ask him, what did he do for the child's birthday? Because I know that I threw the child a party, as I do every single year, while he buys a toy and calls it a day.
You've had this reviewed by the court twice.
Yeah, and I'm going to keep on coming back to court, or I'm going to give my rights up, or I'm going to ask for lesser time.
And that's kind of the argument you gave during the trial with the judge, is that you were just about to give up your child.
Keep dealing with it. I'm not going to keep dealing with it. If
well,
y'all are
your
not
denied at this point, you may object.
Oh, the judge is soft spoken, but he's giving it to her. You know, as I recall, you were on the verge of giving up your child at trial, and now you're trying to sell this same argument that you've lost 2 prior times. How about no?
Your motion is denied at this point. You may object to my ruling. This is a recommendation.
If you're not going to make him exercise his rights, why do he have them? That doesn't make sense to me.
According to the file, he is exercising them.
No, his mother is exercising his rights.
You both are using third parties for daycare and other choices.
Work hours.
All right. Have a good morning. Good luck.
You haven't asked during nothing outside of work hours.
Your Honor.
You haven't asked about nothing outside of work hours.
Thank you.
You're welcome.
Still going till she muted.
I figured you'd get that.
Got muted.
Yeah.
Quick enough, because I'm like, I'm sorry, but you've had this reviewed. You went through a trial with the judge, and I mean, it was barely a year ago, and then the front of the court made a similar recommendation a few months ago, and she was arguing that she was going to give the child up at one point because she couldn't find daycare because she needed his parents to watch. I'm like, okay, no.
That mug is rock solid. He's got a mug with a freaking beak on it. I don't know why I really enjoy that.
All right, next.
All right, we can do Mangione versus
Girl. Barnett. Girl, no, don't do that. Just, I'll mute you now, Miss Jones. All right, now, no more girl, Miss Barnett. Now you tell me.
3K. 3K cash. Yeah. We're done.
We have a first appearance for Gary Cranford.
Oh yeah, we're going all the way to Reno here. This isn't as fun as the last one, but I do really enjoy Darby's disgust with this guy.
Thank you. Oh, how fast this is moving.
Morning. Probable causes found. And Mr. Cranford, you indicated you're going to hire your own lawyer. Were you able to do that? I do not see anyone here for you today.
No, not at this time. I did not.
Okay. For this hearing?
Yes.
Mr. Cranford has expressed he's willing to have the public defender represent him for this hearing, Your Honor.
All right, let me look at one other thing for just a moment. Mr. Cranford, can you tell me how much money you make per week, sir?
Per week, 600.
Okay, and how many people are in your household?
3.
Okay, you qualify for the public defender, sir, so I will appoint them to represent you. You are always free to hire your own attorney at any time, but you do qualify. So let's go forward, beginning with the state.
Okay.
Thank you, Your Honor. So obviously, Mr. Cranford's behavior in this case is disgusting. However, he scores a 3 on the risk assessment. He has no prior documented criminal history. Therefore, the state's not objecting to an unrecognizance release with DAS supervision.
I might have to clip. Obviously, his behavior is disgusting. I mean, it's said with such conviction. You know it's true. I don't know what the charges are. I'm sure they're disgusting. I don't doubt it for one moment.
And no contact with the victim, although I think she's unknown to him, so I don't believe that'll be a problem.
All right, so I see he scores a 3, and I believe he does not live in this community. Is that right, sir?
Correct.
Okay. So here's what I'm going to do, Mr. Cranford. Just because I'm releasing you, your case is not over with. I'm going to give you your next court date. You have to be here on October 3rd at 9 a.m. And what I am going to say as far as your conditions is you cannot go back to the Atlantis Casino or have any contact with Michelle Strong, but I'm not going to do anything more than that at this time. You just have to make sure that you stay away from that place and that person, sir, and
Sure.
show up at your next court date, all right?
Okay, thank you.
Thank you. We have a Ron Grace.
They'll direct you.
Sir,
It's your turn.
I'm sorry, there are two first appearances for Mr. Grace. Probable cause is found on both. Public defenders appointed on both. Let's begin with the state.
Thank you, Your Honor. The state's requesting
It's always a bad sign when somebody is that relaxed in court. It just means they've been there so many times, it has no effect left on them. They're absolutely numb to the experience.
$75,000 bail with DAS supervision, house arrest with GPS monitoring and testing for drugs and alcohol. Mr. Grace scores a 13 on the risk assessment. He had prior unsuccessful pretrial supervision in 2019 and 2024. He's also being held on a fully extraditable fugitive warrant with $1.75 million bail and a failure to appear warrant out of this court. He's got a 2024 felony arrest for possession of a controlled substance, a bench warrant for failure to appear at his mandatory status conference on June of 2024 issued for $5,000. He's got a 2020 felony arrest for violating conditions of release, 2019 possession of a controlled substance conviction, sentenced to 14 to 40 imprisonment, 2017 conspiracy to commit robbery, felony conviction out of California, 2016 conviction for resisting. Looks like he's got some additional history out of California, 2014 battery and theft, 2011 felon in possession of a firearm misdemeanor, 2019 violation of protective order, 2008 battery, and 2007 felony conviction for possession of a controlled substance for sale. So he's already proven to this court that he's a risk of future non-appearance, he's a danger to the community, and he's definitely a risk of continued criminal conduct. So the state's requesting $75,000.
For the defense.
We're going to submit on it, Your Honor.
All right, given the two cases, the holds, the criminal history, monetary bail is appropriate. Since there are two PC sheets, I have to set two bails. So I'll set it at $30,000 each for a total of $60,000. That's taking into account that these are nonviolent accusations. It's bondable or 10% cash. If he posts, he's going to be tested for drugs and alcohol, no weapons, and supervised by DAS.
We bond out. He'll still be held on those California.
And we'll likely be hearing his warrants on Monday morning.
Finish it up here and bang it out.
Next, we have the first appearance for Alberto Mar.
Do what? Don't do anything. Don't do nothing. Yeah. We'll talk soon.
Mr. Marr was not brought to me.
Mr. Marr was not brought today, Your Honor. I'm not clear about why.
All right, we'll set his hearing for tomorrow morning.
Okay, thank you.
We have Joseph Morris. Morning. Probable cause has been found. Public defenders appointed. Let's start the bail hearing with the state.
Thank you, Your Honor. The state's requesting $5,000 bail with DAS supervision and drug and alcohol testing. Mr. Morris scores 12 on the risk assessment. He's also got a PMP hold. He's got a 2023 felony conviction for obtain or use the credit card of another without consent and a gross misdemeanor conviction for unlawful taking of a motor vehicle. 2022 misdemeanor conviction for obstructing. 2022 felony conviction for assault constituting domestic violence out of Washington. 2022 gross misdemeanor conviction for domestic violence out of Washington. 2018, 2 felony arrests for probation violation, 2017 felony conviction for PCS 3+, 2015 felony arrest for failure to appear, 2013 felony convictions for possession of a controlled substance with intent to sell and conspiracy to violate the Controlled Substances Act, and a 2011 felony conviction for possession of a controlled substance. So risk of future non-appearance, high risk of continued criminal conduct, so the state's asking for the $5,000.
Well, he looks like a rug dealer. He acts like a rug dealer. I'm thinking he just might be a rug dealer.
For the defense?
But we're asking for that to be made at least bondable, if not an OR. Again, this is another one of these cases in which someone is jaywalking, they're stopped, they're searched. He consents to the search. And so we were able to verify that he does have an address in Elko. He was in a halfway house. He just got a job when he's working through a temp agency there. So he has ties to the community and reasons to be here. But even at $5,000 bondable, that $500 that he had to put down as 10% cash would end up holding him.
Well, he's got a hold from parole and probation, so until he resolves that, he's not going anywhere in any event. And he scores a high risk. He's already on supervision. I think this warrants a monetary bill. I will set it at $3,000. That's bondable or 10% cash. And if he posts and the hold is lifted, he'll be supervised by DAS and tested for drugs now. We have Omar Saldivar Chacon.
Morning. Judge, might I have a brief moment before we begin?
Sure.
You're about to see Darby's soft side here. Brace yourselves.
Go ahead. Ms. Phelps,
Yes.
I hate to be so direct. Would you be willing to make an OR recommendation on this one? This gentleman has a job, but that job is not open at this time. If we can't get an OR recommendation, then we would like to continue this matter tomorrow. Make sure we reach out to his job, contact that person, make sure that he is in fact working there, that he still can be working there, that he can do those things so that he can be out of custody. This is a DUI causing substantial, and I understand the state's concern, but regular drug testing would perhaps assuage the state.
Yeah, so I honestly, I've been struggling with this one this morning. It originally came in as a DUI first, it looked like, and then they amended it to the DUI causing substantial due to the information about the victim having a broken collarbone. The state's concern is obviously that it's a mandatory prison case if he's convicted. However, he has no prior documented criminal history, and so the state is not objecting to an OR with a SCRAM monitor, GPS, since this is a prison mandatory charge, DAS supervision, and testing for drugs and alcohol.
Did we go forward today, Mr. Blanford?
I think we did, Your Honor. I'm sorry if we cut you out of that discussion. I apologize. I just wanted to make a strategic decision.
All right. Is there anything else the state would like to say?
That would be it, Your Honor. Thank you.
We'll submit it on that, Your Honor.
So, sir, I'm going to release you, but there are going to be conditions. The case is moving forward, and if you break these conditions while you're being supervised, you can be returned to jail. Do you understand that?
Yes, ma'am.
All right. So you're going to be on house arrest with the GPS location device. You're going to be for alcohol, and you also have to show up at your next court date and be supervised by DAS, if I didn't say that already. So your next court date's October 3rd at 9 a.m. Make sure you're here. And again, make sure you show up for all your testing, however they ask you to do it. And they are also going to conduct the DUI rant, which is an assessment for you. And they can adjust the testing accordingly as needed. So those will be the conditions, and you're going to be on house arrest. You can go to work and run essential errands while you're on house arrest, but you have to set that up and follow through with DAS to make sure they know your schedule and know what you're doing to be allowed out of the home while you're on that GPS. All right?
Yes, ma'am.
Okay. Thank you. All right, counsel, I believe that was the last one I had. Did I miss anybody or any questions needed?
I believe that's it.
Thank you, Your Honor.
All right. Thank you all. Have a good day.
DDC? Yes, sir. Can we start out with Memphis Douglas, please? Followed by Ryan Henderson. Yes.
Henderson. Yeah.
Douglas first, followed by Henderson.
Have a seat. Memphis Douglas.
All right, calling case number 240-594-0901, Peterson, Michigan versus Memphis Douglas. Appearances, please. Mr. Upshaw.
Your Honor, Randall Upshaw on behalf of Mr. Douglas. We waive the formal readings and mute to the charge.
All right, court order not guilty plea on behalf of Mr. Douglas. Mr. Upshaw, I read the facts of this report. Somewhat egregious. Can you give me a reason as to why I should not give a cash bond for your client?
Yes, Your Honor. Without trying to throw daggers, Mr. Douglas came to my office. I called Detective Schwab. Mr. Douglas talked to Detective Schwab on the phone and arranged the 10 o'clock meeting. When he arranged the 10 o'clock meeting, his family said he should take a lawyer in there with him. He came to my office, but he came at 5 p.m. I immediately called Detective Schwab and said, I can't make it at 10 a.m. Can you call me?
Hold on, Mr. Upshaw, can you give us your P number, please?
I apologize, Your Honor. 4.
This is an interesting case. This attorney does a seriously good job under the circumstance. You may not like the result. I'm not sure I do, but the attorney does a really good job. He makes the fly lawyer look like an amateur. I'm just saying. Okay, no, he doesn't.
3574. Now,
one more time.
43574.
Okay, my apologies. Continue on with your argument.
So, Your Honor, I've left 2 messages asking. Now, detective, instead of calling me up to reschedule the next day, he sent the police out to arrest Mr. Douglas. As stated, Mr. Douglas been in contact with him himself. I've left 2 messages trying to schedule an appointment. Mr. Douglas has no felony convictions on his record, Your Honor. Mr. Douglas, from what I'm hearing, is that there was an accident and they believe Mr. Douglas and another individual was in the car. Now I'm assuming they arrested and charged Mr. Douglas. But Judge, it's 2 reasons for a bond. One, the belief that he would not appear. And as a court officer, I'm gonna say I immediately called Detective Schwab twice and left messages. I just couldn't make it at 10 o'clock in the morning because I was in court. Criminal conviction, he has none. Detriment and threat to the community. Judge, this was, even if the detective's opinion is right, it's a one-time offense where the officers were speeding one way and they said Mr. Douglas, if they believe he was driving, they have to prove that, was coming another way and they had a collision. It's an accident. It happens all the time. It doesn't happen this bad all the time, but Judge, it appears to have been an accident. It may have appeared to be somewhat of a reckless driving. It wasn't no drunk driving. It wasn't no high-speed chase. It wasn't no getaway driving. There was no weapons. There was no intent. Judge, Mr. Douglas is presumed innocent, and he's been constantly, and I have, as a court officer, called Detective Schwab, and I'm quite sure if he was here, he would tell you I have 2 voice messages on his phone saying I would like to bring Mr. Douglas in.
No.
Your Honor, for those reasons, his lack of record notes is not a likelihood of recidivism. It's not like he was a predator. It's not like he was involved in guns, drugs, home invasions, or anything of that nature. Your Honor, I believe he deserves a personal bond.
Is he employed?
Yes, he is. He does roofing, Your Honor.
Roofing.
Yes, Your Honor.
Yeah, that's a motley crew. You might want to give him a bond just for that.
He works for AA Roofing, and it's 3 or 4 days a week. It's not every day because it depends on call, but he does work. He has no criminal convictions. He has no history of a capias. He has shown he's not a risk for capias because he retained me and he talked to the detective, and I left 2 messages with the detective. At most, Judge, what happened here was an accident. At worst.
Mr. Upshaw, I got you. I'm kind of torn, Mr. Upshaw. You bring up some excellent points as you always do, but looking at the investigator's report, the accident, to your point, I get these things happen. We all have been in accidents. You drive long enough, you're going to be in an accident. We all have. But was two things that are kind of troubling here is that the allegation is that he either ran a red light or a stop sign. That's the first thing. And the second thing that the court found particularly troubling is that instead of, as we're obligated to do after an accident, remain on the scene, even though there was a police vehicle, remain on the scene, exchange information, and so on and so forth. And there's allegations in there that they are, not only him, but the passenger got into another car and fled the scene. That's particularly troublesome to the court. But to your point, Mr. Upshaw, he doesn't have a criminal history. He has retained you. And so that kind of rebuts any concern I may have about him fleeing. So I will give your client the benefit of the doubt. $100,000 personal bond, no drinking, no driving. I understand there was no allegations of drinking or whatever, but just to be on the safe side, no drinking, no driving. Probable cause September 24th, preliminary examination October 1st, both in front of Judge Giles. And another factor that has factored me into making this bond recommendation that these are 5-year felonies. And I said he has no criminal convictions, at least felony convictions. And more than likely, for the sake of argument, even if he's convicted, in light of that, he's likely going to get probation. More than likely, not knowing for certain, but more than likely get probation. So those are the reasons why I adopted Mr. Upshaw's personal bond recommendation. Anything else you want to put on the record, Mr. Upshaw?
No, and thank you, Your Honor.
Okay, probable cause September 24th, preliminary examination October 1st, both in front of Judge Giles. Okay, have a good day.
All right, that's what I got for you. That's what I got for you. Not bad. Not bad for a Sunday. When, not just a Sunday, when there's very little court, but a Sunday where I woke up in the city that never sleeps. Oh, yeah. Oh, yeah. Still getting it done. Because I'm a pro. All right. I'm going to send you all over to Biggin. Have a good one. Thanks for coming out. I'll see you soon.